oral argument in case number 1, CAIC 18-00601 M. Smith, petitioner employer versus Industrial Commission, Department of Corrections, and DOA Risk Management. Council, I remind you that, or advise you that this oral argument is being audio and video recorded. So please identify yourselves and who you represent at the beginning of your arguments. Each of you will have 20 minutes in which to argue. Appellant's counsel remind you to watch the clock and reserve as much time as you'd like for rebuttal purposes. And also, please keep in mind in making your comments that we've read the briefs and we're familiar with obviously the facts and procedure of the case, and we've also discussed the matter in conference earlier this morning. Without counsel for appellant, you may proceed.
Thank you. Good morning. George Sarkisov on behalf of the petitioner Wonder Smith. May it please the court. Your Honors, the issue in this case is very simple. Petitioner is not challenging the credibility determinations made by ALJ in this case. The petitioner challenged the results in this matter based on foundational issues. The main foundational issue is that the judge in both the decision upon review and in the original decision issued last summer adopted the opinion of Mr. Kelman, who was hired by the respondents to conduct evaluation of Ms. Smith's loss of earning capacity. This is what we do in determination of temporary or permanent disability benefits in the Industrial Commission. We look at the residuals of the injured workers' injury on their employability, and we look to their loss of earning capacity. That test, as you know from the briefs, based on two aspects. Number one, is their employment that is reasonably suitable, meaning does it fit the permanent work restrictions? Even if standing before you, I admit, as Judge Morgan did, accepting Dr. Sarashabuti's opinion that there are no work restrictions, that does not eliminate the need for all of us to decide the second part of the test dealing with LEC, loss of earning capacity, and that is their work reasonably available to the injured worker given their injury? I would remind for everybody involved that both doctors, Dr. Capon and Dr. Sarashabuti, agreed that there was a permanent injury. Once we have those determinations, we all know that permanent impairment, that doesn't necessarily mean permanent work restrictions. There's case law on that, but I'm not going to go into it. Once we have this test, the jobs need to be surveyed to determine if they fit and fulfill the two prongs of this test.
Well, let's back up a little bit.
Sure.
What your client, Ms. Smith, she had the initial burden to show a loss of earning capacity, correct?
Yes.
And by showing that the date of injury employment was unavailable to her, I mean that she could not do that for reasons XYZ, and that her labor expert would corroborate that, and she had looked for employment and was unsuccessful. How did she, well, two questions. Did she meet that burden? And did the ALJ make a finding on that issue?
Yes, Judge Brown. Both things occurred, and here's how. My client was under obligation to carry the initial burden of proof to see if, given the opinions of her medical providers and her labor market consultant, if the date of injury job as a correction officer too was, again, suitable and available. We did that. Ms. Tischauer relied on Dr. Capon's opinion to say this woman will not be able to come back into the correctional officer industry because she can't do takedowns per Dr. Capen's restrictions. At that point, both Ms. Tischauer and Ms. Smith applied and searched other available work that should be capable of doing. Ms. Smith tried to work as a cook in lighter capacity. She took other jobs. Ms. Tischauer determined that with Dr. Capen's restrictions, she was ineligible for that job because of the physical requirements, and at that point suggested unarmed security guard as an alternative position, with which Mr. Kelman agreed. Mr. Kelman then took upon himself to raise the issue to say, okay, if Dr. Sarashabuti's work restrictions are accepted, meaning none, what is the work out there for her? And he went back and he surveyed 2 different positions, a correctional officer, a detention officer / and a separate youth correction officer with City of Phoenix. Both of those 3 jobs came in resulting in permanent disability. No matter how small, those jobs at that point were not going to pay this woman her average monthly wage, regardless whether she had restrictions or not.
So they are not suitable jobs for them?
They're not. They're not available, Your Honor, and they're not suitable to bring her to the same rate of pay that she was before she got hurt. That's the difference here. That's why you see this small $230 to $320 LEC, or Permanent Disability Award, on a monthly basis. Unfortunately, what Judge Morgan did, she coupled and mingled all of these different jobs, including the date of injury jobs as correctional officer too, just into this general aura of correction officers. And then she determined there is no loss of earning capacity.
Although she could not do the job, there's no loss of earning capacity?
What they're saying is there was no evidence whether her date of injury job was actually available to her. The jobs that were available and suitable resulted in a monthly disability.
So if Judge Morgan would have said the juvenile correction position was available and suitable, and I'm awarding $230, whatever, wouldn't that be sustainable? On appeal, I mean, by the evidence on this record, at least, on this record.
On this record, Your Honor, I would go and say if she selected the correctional officer 1 / detention officer, it is sustainable. Because a market survey was done into that job. It is reasonably available per Mr. Kelman's own verification and discussions with Sergeant Diaz at the Department of Corrections. And number 2, that job was suitable because it allowed, there were no limitations once Judge adopted Sarah Shabuti's work restrictions.
So contrast that with what Judge Morgan actually did.
And what she did, she assumed, based on no survey whatsoever, Your Honor, that Correction Officer 2 was available despite any issues that my client have had with that employer on full-time basis, resulting in the same pay as at the time of injury, resulting in no loss of earning capacity and no permanent disability. We questioned that, Your Honor, for a very simple standard that we have. A survey has to be done. Opinions of labor market consultant from prior cases, what that labor market consultant may have done over 20 to 25 years of their experience. I don't question Mr. Kelman's credibility or his skill as an expert. In fact, I've used him as an expert in prior cases. But when we go back and we look at what experts do, we always look at every position. We say, did they do a market survey? Is this job suitable and available, reasonably available? And what's the evidence in backup of that opinion? Because it's not only the opinions that we care about, it's the verification of that actual job being in existence and for the applicant to be eligible for that job. We don't know that today.
And it seems to me like we start being circular here very quickly. No loss of earning capacity. She's suitable for a detention officer, to serve as a detention officer. And I know she has a history of it, and you know, God bless her for it. I don't know that I could do that job. She has the history, no loss of earning capacity, just an inability to get anybody to hire her. Isn't that right?
You're there. You're almost there, Judge Jones.
Give me one more then.
The-
Finish it out for me.
Yeah, here's one thing I would tell you. It's the particular jobs that need to be separated in this. The titles matter, and the ability of her to get that job. So you're right there.
So how can you have no loss of earning capacity, just no job?
Because you have to have a job that's reasonably available to the injured worker after their injured state. Look, let me just finish. And what I'm asking here is that we need to verify that she's eligible for that job. Let me give you an example.
Please.
Mr. Kelman concluded that even without any work restrictions, okay, resulting from this injury, if Ms. Smith goes and applies for a youth detention officer with City of Phoenix, she's going to make less money. She's going to have a permanent disability because that job is not going to pay what she was receiving at the time of her injury. Mr. Kelman was aware of that second responsibility, the second part of the test, which is reasonable availability. He gives us to us for correction officer, detention officer, and this youth detention officer. But he doesn't take the last step, Judge Jones, to go and speak with DOC and say, hey, by the way, we're going to argue that she can go back to a regular duty job that she had at the time of the injury. Is that job, by the way, still available to her?
And the answer would be?
We don't know, Judge. He never did it. He never asked those questions. He assumed that she was eligible for rehire. He never asked that. He assumed the job was available to her at the same capacity, with the same requirements, with the same qualifications, with everything being the same, but he never verified, Judge. That's why I'm standing here before you. All I ask, if we're going to tell an employee with a shoulder injury after 22 years of service that she can't go back doing that job and she has no permanent disability, we need to do our homework. We need to present the evidence to judge and say, Your Honor, here's what we considered. And she's eligible, and there's plenty of these jobs. She's competitive at it. They're going to consider her, despite that she resigned earlier because of her sick husband and bad shoulder. We didn't do the same exercise, Judge Jones, that we did for all of these other positions. But yet the judge relied on it by combining all of those positions under one single identification as correction officer.
So is the state of the record such that only by returning to her date of injury job that she would have no loss of earning capacity?
Correct, Judge Thompson. That's the only
That's
way.
what you're saying, when you have to distinguish between jobs in the correctional field.
Yes, Mr. Kelman himself did it, Your Honor. He just didn't go to the last one, to the date of injury job and ask, hey, can she still qualify for it? And what's the pay, and are they going to take her back?
And was that job an armed officer job?
Yes.
And isn't there testimony that she can no longer do that?
She had trouble shooting the gun. There's some testimony to that. But she never went through the actual testing that they take upon return to work.
So there's an assumption that the physicalness, if there is such a word, of not just carrying the gun on your hip, but pulling it and shooting it, would be something that she could not do, although she was otherwise qualified to go back to prior employment.
Well, I think that's from her perspective, Judge Jones. I don't want to say from perspective of a medical provider because I don't want to muddy the waters. Dr. Sarah Shabudi said she can go back and do full aspects of her job, physically. He's not a labor market consultant. The second part to that exercise is that job still reasonably available to her? And if
Define reasonable availability.
Sure.
I mean, if she is not, she can go back to that job, there's no limitation on her, except that she can't do the stuff she needs to do.
From her perspective.
But they're saying she can pull a gun and wield it.
Correct. But she wasn't actually tested for it. But the reasonable availability for, well, Your Honor, you just asked me. I don't want to say that doctors are saying something different.
No, I appreciate your explanation.
Okay.
I really do. It just seems to me like we're going in circles here, where circles aren't called for.
With regard to reasonable availability, to what extent is your client's age relevant as far as whether the job, the date of injury, employment is reasonably available to her. And I'd like you to address that in context of what the statute says, and then also as a practical matter, as her age as of today, or at the time of the hearing, or at the time she was looking for alternative employment.
Will do, Judge Brown. Ms. Marlacci called me on it in my brief. She was absolutely right. I looked at the statute. It is at the time of the injury that we look at the age of the applicant to determine their eligibility for a position, not
True, but
when
let
the
me
actual
push
age.
back on that just a little bit.
Okay.
It says that, if I recall correctly, the statute says, among other factors, you may consider that, it suggests the ALJ may consider, among other factors. Are you saying, are you agreeing then with opposing counsel that we would be foreclosed from considering, or that the ALJ would be foreclosed from considering age? Even if a person was, say, 75, 80 years old? Later on down, 10, 15 years after the injury occurred?
Not at all, Your Honor. What I'm saying is it wasn't considered. It wasn't
You're saying
addressed.
it just wasn't part of the
Record.
proceeding for all intents and purposes?
Correct. Correct.
How can that not be part of an evaluation of whether or not today she is, and I use competent in the broadest sense, capable, competent, prepared, ready to go fill that job if it's available?
Well, Judge, I think we have to go by the statute, and the statute reads at the time of the injury. So the presumption then comes in that if she was employable at the time she got hurt, she would be employable, given it would be same age consideration, 2 years later, 3 years later when she returns. Now, do I have an issue with that? Yes. I don't think that always meets with the reality, but the statute speaks for itself. What I'm saying is, if we're going to go by the statute and evaluate loss of earning capacity, I would like to have that actually be presented to the employer and say, would you take this person? Is she still considered given her age? None of these inquiries were made with regard to the specific factors and age and other factors, among other things, Judge Brown, as you raise it. That was addressed in Zimmerman. We need competitiveness. We need to know ratios. How many are available? Mr. Kelman said there's hundreds of them. Well, how many applicants? We don't even have that.
How many applicants are in their 70s, or 69 or 70?
That's right, Judge Brown.
Well, I thought did Ms. Smith testify that she believed that she was unable to even get interviews because of her age? Interviews with the other, she had testified that she applied to several non-government entities, and she was unable to obtain interviews because of her age. Is that not true, or did I misread that?
No, you're correct. That's in the record. She went outside and tried to look for other work. She couldn't. She finally gave up and decided that she is going to go and retrain herself through this AC and do the air quality testing, which she thought that she's going to be able to do.
Of course, that would only go to her initial burden of the LEC test, right? Perhaps.
Yes, her continuing to find alternative positions and now realizing that she needs to re-educate herself.
And so that certainly isn't as someone in their mid-60s. She's not out searching for a job for somebody in the mid-60s because she's not a placement agency.
Correct.
She's looking for herself, and she's not in her mid-60s.
Correct, Your Honor.
I guess I'm having a little trouble. These layers don't seem to meet up at any point.
Well, sometimes they don't, and this is the problem. She's going in reality looking for work in 2018, yet we're evaluating her back at the date of the injury. And that creates a disconnect in itself. My simple issue is if the evidence was presented to the judge with all of the Zimmerman factors into consideration of the availability of this job, we wouldn't have this dispute. But the only time the survey was done, both of those surveys for the two different positions, arguably three, the detention officer, correction officer, and youth detention officer, all resulted in loss of earning capacity, even assuming no restrictions. And that's a foundational issue. It's not a credibility between experts. I'll reserve my 2 minutes for rebuttal. Thank you, gentlemen.
Thank you. Yes, Counsel.
May it please the court, my name is Maria Morlacci, and I represent the Arizona Attorney General's Office, the state of Arizona, the Arizona Department of Corrections, and the state's insurance company, Risk Management. Now, in this case, the applicant did not meet her burden of proof to establish lost earning capacity. I've reviewed my opponent's reply brief, and on page 4 of his reply brief, he discusses the burden of proof and the shifting of the presentation of evidence. And within his reply brief, my opponent discusses the Landon case. Landon came down from this court in 2016, and I'd like to read 2 sentences from Landon. Quote, "A claimant has the burden of proving a loss of earning capacity, which requires establishing his inability to return to date of injury employment and either to make a good faith effort to obtain other suitable employment or to present testimony from a labor market expert to establish his earning capacity. If the worker meets his initial burden of proof, the employer or carrier must then go forward with evidence demonstrating the availability of suitable employment and or the lack of causal relationship between the claimed loss of earning capacity and the injury." That is Landon. The burden of proof, as outlined in Landon, never shifts. The burden of proving a loss of earning capacity is always with the applicant, the injured worker. It is the presentation of evidence that shifts, but only if the applicant meets his initial burden of proof. I'll now...
So in this burden of proof, it clearly plays a huge part in this process. What's she needing to prove? That she could have done this job 7 years ago? Or that she can still do the job and is available to go out and do it today?
Well, she needs to prove 2 prongs with regards to loss of earning capacity, and it's the prongs that you have been discussing. Suitability of a particular
But
job.
we're talking about initial burden.
Correct.
Why is suitability?
Well, because case law outlines.
Okay, so let's just jump to the heart of what I think the issue is. Where did the ALJ make a finding on this issue? And isn't that critical?
Yes, absolutely. And I'll refer to the decision upon review. You'll find on page 3 of the ALJ's decision upon review, she states in item finding number 6 and finding number 7, she finds Mark Kelman, the state's labor market expert, his opinion is well-founded and correct, and therefore she adopts him over the applicant's labor market expert. And most importantly is finding number 7, where the ALJ explicitly states that the applicant has not met her burden of proof, given her case in chief.
But that's not very specific. That's very general, counsel. That doesn't address the first prong in Landon, Zimmerman. I mean, by the way, Landon, I think, just belies on Zimmerman. I mean, the leading case, I think, case law is Zimmerman. To me, what I'd like to know here is, how does the ALJ's overall ruling comport with Zimmerman, or the principles of Zimmerman? Clearly, I mean, are you saying that the ALJ just disbelieved the claimant here? Because I don't find that I don't see that. I don't know that we're to the experts yet.
Yeah.
Let's talk about the claimant's testimony that she couldn't go back to work.
Well,
and that she didn't believe that it was a suitable position for her.
well, the applicant's testimony, yes, is utilized by the administrative law judge. It's certainly not ignored. But when you talk about the 2-prong test to establish whether she's entitled to permanent workers' compensation disability benefits, you're looking at, number 1, suitability, and suitability is defined as this injured worker's ability to go back to her date of injury employment. Whether we look at permanent restrictions and limitations, education, experience, background.
Age.
Age at the time she was,
Among other factors is what the statute says.
correct, but age at the time she was
Right,
doing her
understand.
work.
Yeah.
And when she was doing her work as a correctional officer, at her age, whatever age that was, she was able to do it well, and she did it for 22 years. You don't look
True.
at her today.
Is a 64-year-old with a disability this exact same person as a 71-year-old or 70-year-old with a disability?
Well, I appreciate your desire to make that comparison, but you cannot make that comparison here, respectfully. You must look at this claimant when she was doing her correctional officer work, look at her age at that time. Was she able to do it? Yes, she was able to do it.
Let's change the facts.
Okay.
Just because that's what we do in the law is we test the outer limits here. Let's say she was 79, right? At the time of the hearing, let's say she was 79.
At time of?
Of the hearing, 79.
Okay, at the time of her hearing, which was subsequent to date of injury, okay?
Yes. So that your opinion still doesn't change. That doesn't affect one iota.
Correct. Per the statute, you look at her when she was working, you look at her
But the
date of
statute
injury.
doesn't say only. It doesn't. It says among other factors.
But it talks specifically with
So
respect.
it sounds like you're saying we're precluded from taking her age into consideration when we're supposed to take in the fact that she has a prior disability. I mean, she had a prior disability. She still has some kind of a permanent disability. I'm not sure exactly how you label that, but she still does, correct?
Well, Judge, Your Honor, the administrative law judge adopted Dr. Amit Sharasabuti's medical opinions, which resulted in 0 permanent restrictions and
I
limitations.
know her permanent restrictions, but didn't she still have a permanent
She had
disability?
no, she had a percentage impairment, but that does not equate to inability to do your job.
No, I
There are-
understand that. True. Okay, go ahead, please.
There are a lot of people who are hurt on the job, they have surgery, they sustain a percentage impairment, they rehabilitate, and then they are able to go back to work and they do their jobs just fine. Percentage impairment does not equal inability to do your job, does not equal permanent physical restrictions and limitations. They're two separate
And my
things.
concern here is we have a claimant who said, I can't go back to that job. I can't
Correct.
aim a weapon
Correct.
Appropriately
Correct.
to pass
But-
the test.
But then you
And
have...
I looked for employment. What's wrong with those two things? Then the burden shifted. If you want to cut burden of proof, burden of persuasion, burden of presenting evidence, however you want to phrase that, then it was clearly upon your client, the carrier, to present that evidence in a persuasive manner about whether the job was reasonably available.
Well, yes, the ALJ took the state's evidence. However, as I pointed out a moment ago, in the decision upon review, the ALJ clearly said the applicant did not meet her burden of proof. Now, the ALJ could have, at the end of the applicant's case in chief, ended the proceedings there. Why? Because in her mind, in the ALJ's mind, the applicant had not met her burden of proof, and therefore we do not shift the presentation of evidence, and that is pursuant to Landon.
But what was deficient in carrying her initial burden?
If you'll look at the ALJ's initial decision, she outlines the testimony of the applicant, she outlines the testimony of the applicant's doctor, she outlines the testimony of the applicant's labor market expert, and she does the same with respect to the state. And then, because she has the authority to do so, the ALJ weighed all of this and said, based on everything I've seen, based on everything I've read, based on everything I've heard, based on the record in totality, I find that the carrier's witnesses are more credible, and I will adopt the carrier's witnesses to find that this applicant has not carried her burden of proof, and this applicant has sustained a 0 loss of earning capacity.
But was it rebutted that she couldn't hold a gun?
Well, yes, Dr. Amit Sharasabuti's, the state's doctor, testified that he had viewed diagnostic testing, he had viewed or he had read medical records, he had examined the applicant 2 times, he had done physical testing of her, and his conclusion was this applicant has no permanent restrictions and limitations causally related to the industrial injury, and therefore he opined that there were no permanent physical restrictions and limitations, and the industrial injury had healed, and she could go back. He would release her to her regular date of injury work.
But he indicated no familiarity with the requirement that she hold a gun?
No, Your Honor, yes, he knew that she was a correctional officer too, and he opined that despite her work requirements, whatever problems she might continue to have, whether it's arthritis of the shoulder, that is not causally related to our date of injury. If you're going to award workers' compensation disability benefits, those must be awarded strictly due to the industrial injury. There are other forms of disability out there. Social Security disability, short-term disability, long-term disability, and workers' compensation disability.
Her injury was to her shoulder, and she said it was because of her shoulder injury that she couldn't hold a gun.
She said that, and of course, that is her opinion, but then we need to go to medical expert opinion. And of course, we've got the applicant's doctor, we've got the carrier's doctor, they're on opposite sides. Who has the authority to resolve this conflict?
Did the carrier's doctor, I'll call him Dr. S because I can't say his last name, pardon me, but did he say that she could pass a test? Did he opine? Yes, she should be able to pass the test required by the Department of Corrections, or was there any evidence about what that test even involves for as a threshold point for getting her job back?
Your Honor, I don't remember the specifics of his testimony. It was lengthy, and I don't remember the specifics of his written medical IME reports, but he was made well aware of her job requirements as a correctional officer. He knew what those requirements were, and he rendered his opinion that she had healed from the industrial injury.
Understood, but does it really matter? Because we're talking about loss of earning capacity here.
Correct.
I mean, I'm still getting hung up. I don't think that she had an initial burden. Let me repeat. You quoted from Lannon, but said, I'll quote it back to you. The burden of proving an LLC is on the claimant, which requires establishing her inability to return to date of injury employment. Inability. That says nothing about being reasonably available or suitable. It just says her inability. And
yes.
And either to make a good faith effort to obtain other suitable employment. Again, going back to Judge Thompson's questions, I'm not seeing what in the record contradicts anything or undercuts anything that she presented about it. She said, I can't return to my date of injury employment, and I've looked for employment.
But you can't.
How did the carrier refute that evidence?
You can't strictly look at solely the applicant's testimony. You must look at the entirety of her case, and then you must consider if she has met her initial burden and the judge allows a shifting of the presentation of evidence, then you consider the carrier's case, and you weigh all of that.
Why wouldn't the ALJ just say she has not met her initial burden? Why waste everybody's time? Why not just say she didn't meet her initial burden?
I can't speak for the ALJ, and I have to tell you that she has complete latitude to do what she did.
Do you have case law for that?
That she can go ahead and take the carrier's case.
And not make any finding on the initial burden.
Well,
because you have to agree, there's no express finding on the initial burden.
With respect to the initial judge's decision here?
Yeah, either one. The decision. There is no specific language saying the claimant did or did not meet her initial burden under Zimmerman, Landon, et cetera. It's just not in there.
Well, with regards to the ALJ's initial decision, if I remember correctly, she uses the words, I adopt the testimony of the state's experts to find a no loss of earning capacity. It is within her decision upon review that she explicitly states the carrier has not met her the applicant has not met her burden of proof. So I think, Your Honor, that perhaps the court is hanging on too heavily to terminology. I think if we
That our
allow,
job?
pardon?
Isn't that our job?
Well, I think you have to look at the case in its totality. And you have to look at the totality of the evidence presented by the applicant. And you have to look then, because the judge allowed the carrier to move forward with its case, you have to look at the carrier's evidence. This indeed, in many ways, is a case of conflict in expert opinion. And the judge is paid to resolve those conflicts. And she's in the best position to resolve those conflicts because she's seen the applicant, she's heard her, she's listened to all of the expert witnesses, medical and labor market expert witnesses. She's also been able to question them if she's had any questions. And she truly is in the best position to resolve these conflicts. Her resolution was not wholly unreasonable. It was not an abuse of discretion.
Let's assume that the claimant actually met her burden here. Going on, did Mr. Kelman present competent evidence about what jobs were reasonably available at the Department of Corrections?
Yes.
In the sense that, did he present evidence about how many people applied for that job? Because that's the Roberts
Yes.
case. That's
Yes.
square on. Roberts involved a Department of Corrections employee, if I'm not mistaken. I mean, very similar. What evidence is there in this record that shows he spoke and he presented evidence about the hundreds of positions available, how many are available right now at the time of the hearing, or when whoever he talked to?
I'll refer you to his report, which is in evidence, and I'd like to discuss that in a bit of detail. But first, let me also acknowledge this. My opponent, on several occasions in his brief, indicated that it was the state's labor market expert that didn't even know the correct job title that this applicant held, date of injury. That is incorrect. So first, we establish that Mr. Kelman indeed knew what the applicant was doing on date of injury, what her correct job title was. And with respect to that, you'll find it in the hearing transcript of May 1, 2018, on page 53, where I was doing a redirect of Mr. Kelman. And I said on line 13, Mr. Kelman, your understanding of her date of injury job is correctional officer for DOC, is that right? Answer, right. And I'm looking at documents that show the, date of injury, and it's signed by her, and it has corrections officer Roman numeral 2. So as foundation, he knew exactly what her job title was. We then turned to his labor market report, which is dated August 11, 2017. It's in evidence. If you go to page 10 of Mr. Kelman's report, at the very top, he states, it should be noted that if Ms. Wanda Smith actually reapplied and interviewed, she would have a no loss of earning capacity. But in the absence of her not applying to the job, a hypothetical approach was used with individuals with several years of experience. A small monthly entitlement is noted above. When he talks about individuals with several years of experience, he is talking about...
How many people applied for this job? For correctional officer 2 position?
Let's look at page 7 of Mr. Kelman's August 11, 2017 report. Within that report, that specific page, Mr. Kelman outlines the sufficient specificity required by case law to prove reasonable availability. That is the second prong. Suitability is more of a medical question. Reasonable availability is a labor market question. If you turn to page 7, you will see that Mr. Kelman notes the date that he contacted the DOC. He notes the person that he spoke with. He notes the facilities at issue, the Buckeye and the Perryville prison facility. He says that yes, there are current openings pursuant to the recruiter that he spoke with. Annual openings are in the hundreds. The last hire was within the last 2 weeks. There are 4 to 6 qualified applicants for these positions at any one time, and they are full-time positions, et cetera, et cetera, et cetera. The
4 to
specificity,
6?
4 to 6 for each one. 4 to 6 qualified applicants for each opening that
Does
there
it say that, or
is.
does it say 4/6?
It says qualified applicants, 4/6.
What does that mean?
I read that to mean, on average, 4 to 6. For every open position, there are 4 to 6 qualified applicants.
Isn't that a ratio? I believe then they go on to say that the ratio of X, whatever it is, it's 4/6.
Oh, well,
And that's specifically referred to as a ratio, I believe.
well,
Referred to that.
I read that to mean that there are 4 to 6 applicants, qualified applicants for every one opening. Reasonable availability looks at the competition in the open labor market. So if you've got one opening and you have 1,000 applicants, that's not reasonable availability. If you have one opening and you have 4 to 6 qualified applicants, that is reasonable availability.
We'll take a look at that report. Okay, thank you.
I would respectfully
yes.
ask that this.
I'll give you 30 seconds to wrap up.
Thank you. I would respectfully ask that this court consider the entirety of the record and affirm the ALJ's decisions. Thank you.
Thank you. Okay.
Your Honor, I would like to just quickly point out exactly on the same page of Mr. Kelman's report, page 7, that very position that he discussed as correctional officer at Buckeye facility actually results in loss of earning capacity and a permanent disability of $230 a month. He did not check correction officer 2, and if he knew it and didn't do it, we have bigger problems here. I was giving him benefit of doubt that he didn't know, because usually he checks. So if this is the case, that he didn't check and whatever he did check results in loss of earning capacity, then there is an LEC in this case. The issue with credibility, Judge Brown, you raised issues with the applicant. I don't see in any of these decisions where the ALJ explicitly found applicant not credible. No other evidence and no other witnesses were presented to challenge her credibility. If there were some testing or some employment offered to her after she resigned due to family circumstance with her husband, there would have been somebody from DOC, including Sergeant Diaz, testifying the job was available. She should have applied, we would have hired. We did not have any of that evidence. Once the burden of proof shifted, and it did shift, the respondents were in the best position to contact their own employer and to lay out the evidence where she can come back and do her job and that she would be hired.
But what are we to make of this finding that the claimant didn't meet her burden? I mean, can that be read in some other way as saying she didn't meet her initial burden?
No, Judge Thompson, I don't think so. If she did not meet her initial burden, LJ Morgan would said, George, nice try, but you failed to carry the day. I'm not even going to spend listening from defendants and respondents' testimony. I'm not going to look at any of those things. You failed. I'm issuing the award. She did not do that. She looked at the testimony of the experts because the labor market consultants, if Your Honors...
You don't really get to the experts unless the claimants got past the initial burden, do you?
Well, my feeling that she didn't, she just connected all that together, made a decision in her head, there's no work restriction, so there is no loss of earning capacity, and we move on. I think there's some part of Landon that keeps coming back in the thinking here, in the process of determining these permanent disability cases. But the burden was there, she considered it. And Judge Thompson, I will offer that Mr. Kelman and Ms. Tischauer agreed that if the work restrictions are awarded, she sustained a loss of earning capacity entitled to $972 per month as an unarmed security guard. They also agreed that if there is other jobs available and she can get those jobs, she has a certain amount of LEC.
Well, did anybody ever address this assertion that she couldn't hold a gun? Or was there...
Just a testimony from the applicant, Your Honor, and I believe Dr. Sarashaburi was not even provided with a job description in terms of what her responsibility are. He basically testified, I've examined these folks in the past, I know what detention or correction officer does, and we just went forward.
Counsel,
Thank you.
Thank you both for your arguments this morning. We will take this matter under advisement and issue a decision in due course. We'll take now a brief recess to allow the courtroom to be prepared for our next argument.